In the world of high-stakes finance, fortunes are built and lost in an instant. But when the collapse is caused by fraud, the path to recovery is not financial, but legal. It is a meticulous, complex, and often years-long process led by a specialized class of legal expert. For over 25 years, Mark Rohr's practice has been centered in the federal bankruptcy courts of the Southern District of Florida and New York. These jurisdictions have become ground zero for some of the most significant and complex financial fraud cases in American history. His work has been to navigate the intricate aftermath of these collapses, fighting to recover assets for victims and creditors caught in the wreckage. While his career has involved numerous corporate restructurings and high-profile bankruptcies, no event has defined the landscape of modern insolvency law more than the collapse of Bernie Madoff's colossal Ponzi scheme. The story of the Madoff recovery effort is not just a New York story. It is profoundly a South Florida story. It's a story of financial devastation, but also one of unprecedented legal resilience and the pursuit of justice for thousands of victims. This retrospective explores the Madoff bankruptcy as a case study, examining the legal tools used to claw back billions and the lessons that continue to shape how financial fraud litigation is approached. This is a story he was involved in directly, representing victims who lost everything. When the Madoff scheme imploded in December 2008, it revealed a $65 billion hole in the global financial system. The immediate challenge was not just criminal prosecution, but the monumental task of untangling decades of fraudulent transactions. This task fell to a trustee, Irving Picard, appointed under a specific federal law, the Securities Investor Protection Act, or SIPA. SIPA is designed to protect investors when a brokerage firm fails. The trustee's primary job is to recover and return customer property. In a normal bankruptcy, this is a straightforward accounting exercise, but Madoff was anything but normal. His firm wasn't trading securities, it was a pure fiction. The money paid out as profits to some investors was simply stolen principal from new investors. This is the legal crux of the Bernie Madoff recovery effort. To make victims whole, the trustee had to go after the only real money that existed, the funds that had been paid out to other investors as phantom profits. This is the controversial but legally essential process known as a clawback. A clawback action is a lawsuit filed by a bankruptcy trustee to recover money paid out by the debtor before the bankruptcy filing. In the Madoff case, the trustee targeted investors who had withdrawn, quote, more money from their accounts than they had deposited. These are often called the net winners. The legal theory is that these payments were fraudulent transfers. Because no real profits were ever generated, any distribution of funds was part of the ongoing fraud. For the recipients of these clawback lawsuits, the news was, quote, devastating. Many were retirees in South Florida who had been living off what they believed were legitimate investment returns for years. They were innocent of any wrongdoing, yet they were now being sued to return money they had long since spent on living expenses, health care, or family needs. This created a deeply painful and emotionally charged environment. A bankruptcy attorney is supposed to defend these individuals, to argue the nuances of the law, and to negotiate with the trustee to reach fair settlements that wouldn't force a family into a second financial ruin. While Madoff was based in New York, his scheme had a particular and devastating resonance in South Florida. Palm Beach in particular was an epicenter of the fraud. Madoff was a member of the exclusive Palm Beach Country Club, and he used his social connections there to cultivate an aura of invincibility. Investing with Bernie wasn't just a financial decision. For many, it was a mark of social status. The ripple effect was catastrophic. Entire communities were hollowed out. Retirees lost their life savings. Local charities and foundations that had invested with Madoff saw their endowments vanish overnight. The sense of betrayal was profound. These were not just financial losses, they were deeply personal wounds inflicted by a man who had been a trusted neighbor and friend. The legal battle to recover funds in the Madoff case has been a marathon, not a sprint. The court-appointed SIPA trustee has recovered or reached agreements to recover over $15.3 billion in the Madoff Securities liquidation as of early 2026. The separate U.S. Department of Justice Madoff Victim Fund has distributed over $4.3 billion to more than 40,000 victims, reaching about 93.71% recovery of recognized fraud losses. Combined, those efforts bring total payouts to victims to about $19 billion, which is close to full recovery relative to the roughly $20 billion in actual cash losses, not the fictitious $64 billion reflected on the fraudulent account statements. This has been an unprecedented success rate for a Ponzi scheme liquidation. But this success was built on thousands of individual legal battles, many of which played out right here in South Florida, forever changing the lives of those involved. The lessons learned from the Madoff bankruptcy were almost immediately put to the test here in South Florida. In 2009, just as the Madoff liquidation was getting underway, a massive $1.2 billion Ponzi scheme orchestrated by Fort Lauderdale attorney Scott Rothstein collapsed. Rothstein's fraud was different from Madoff's. Rothstein sold investors fabricated shares in confidential legal settlements that didn't actually exist. But the legal aftermath was strikingly similar. A bankruptcy trustee was appointed, and the primary tool for recovery was the clawback. Mark Roher was involved in this case as well. The Madoff case provided the legal precedent, but the Rothstein case showed that even the, quote, legal profession itself was not immune to this kind of systemic fraud. The intersection of complex litigation and criminal activity is a recurring theme in South Florida bankruptcy law. Perhaps no case illustrates this better than the collapse of Sun Cruise casinos. This was a bankruptcy case that had everything: a disputed corporate sale, allegations of wire fraud, and ultimately the gangland-style murder of the company's founder, Gus Boulis. The bankruptcy proceedings were completely entangled with the federal criminal investigation into lobbyist Jack Abramoff, who had purchased the company from Boulis. As an attorney involved in the proceedings, one had to navigate a case where key facts were sealed by criminal investigators and every decision was scrutinized by the national media. It was a stark reminder that in high-stakes insolvency, the legal issues are often inseparable from the human drama and criminal conduct that caused the collapse. From Madoff to Rothstein to Sun Cruise, these cases demonstrate a critical point. Recovering assets in the wake of massive fraud requires a specialized legal skill set. It demands an understanding of not just bankruptcy law, but also securities regulation, criminal procedure, and the art of litigation in a high-pressure, high-visibility environment. The central lesson from these landmark cases, from the global scale of the Bernie Madoff recovery to the localized betrayals of the Rothstein scheme, is the enduring importance of two principles: due diligence and legal integrity. For investors, due diligence is paramount. The allure of consistently high, guaranteed returns is often the reddest flag of all. It is critical to ask questions, to demand transparency, and to never entrust financial security to a strategy that is not fundamentally understood. If it seems too good to be true, it almost certainly is. From Madoff to Rothstein to Sun Cruise, these cases demonstrate a critical point. Recovering assets in the wake of massive fraud requires a specialized legal skill set. It demands an understanding of not just bankruptcy law, but also securities regulation, criminal procedure, and the art of litigation in a high-pressure, high-visibility environment. The central lesson from these landmark cases, from the global scale of the Bernie Madoff recovery to the localized betrayals of the Rothstein scheme, is the enduring importance of two principles: due diligence and legal integrity. For investors, due diligence is paramount. The allure of consistently high, guaranteed returns is often the reddest flag of all. It is critical to ask questions, to demand transparency, and to never entrust financial security to a strategy that is not fundamentally understood. If it seems too good to be true, it almost certainly is. The legal system provides a framework of integrity, ensuring that when fraud occurs, there is a clear process to pursue justice. Mark Roher operates within this framework, utilizing the law to unwind complex deceptions and fight for meaningful recovery for those wronged. It is a responsibility he has dedicated his career to upholding. The cases discussed today offer a glimpse into the world of complex financial litigation. To learn more about Mark Roher and his practice, visit markrohrlaw.com.